Okay, so this part I'm going to be just reviewing the difference between an A-B trust and a simple trust. This applies for just married couples. So again, we went over this. You've seen this diagram time and again. So the protections that we were talking about at this first level, at the death of the first spouse, we have the protections there. We can again build in some creditor protection. It's going to be an extremely, extremely restrictive distribution scheme, and it's something that would be reserved only if you know that the surviving spouse or any of your beneficiaries, if they have current creditors. Okay, so that's something that you'd want to bring up to your estate planning attorney when you have the meeting with them. Okay. And then the other one that you can build in at the level upon the death of the first spouse is the remarriage protection, stating if the surviving spouse were to get remarried, then they must execute a prenup. If a prenup's not executed, the surviving spouse will no longer be a beneficiary nor a trustee, and the assets in the decedent's trust will be just there for the benefit of the remainder of the beneficiary. And lastly, we can build in protections on the bottom level here after both spouses have passed for the benefit of the beneficiaries. And we can do this if they're blended families. We can do this in a blended family. We can do it in a traditional family. It doesn't have to be that way. And also, if you're a couple and you don't have kids, or your beneficiaries are not kids, they're maybe not your kids, but their nieces or nephews, there isn't really a restriction or requirement that it be your children that we set up the subtrust for. Okay. But here, the subtrusts, we would have them for what we would call, I guess, divorce protection from the benefit of that it's very clear that the assets that your beneficiary receives are their sole and separate property. Just a word that, 55% of marriages end in divorce. So it's a real, there's a really, there's a high likelihood that a divorce could happen, and this would be somewhat protective. It would be protective of your child's separate property assets from being commingled and getting caught up as community property assets, which could be taken in a divorce. Okay. So in a simple trust, some people say, well, gosh, this sounds so complicated. I know that my neighbor next door, her husband died, and it was very straightforward. They didn't split it up into these trusts. So that's what we call a simple trust, or a simple trust is a term of art. So, yeah, but I call it a simple trust or an all to the survivors trust. So here, upon the death of the first spouse, we still split everything. We have the husband share of 50% of the community property, 100% of his separate property. And in the survivor's trust or survivor share is also the wife's in the situation, 50% community, 100% separate property. So in a survivor's, in an all to the survivor's trust or the simple trust, what ends up happening is all of the property just ends up into the survivor's trust. Okay. So then when the wife passes away in this scenario, then whatever's left over will go to the kids. In this circumstance, we said 50-50, but here we said in trust for maybe one child and outright for the other child. So when would you do something outright for one child, but in trust for the other? Many times I'll see this where the client's children themselves don't have kids, meaning there's no grandchildren. So we're really not seeing a need to do that, or maybe that child is not married. Um, or perhaps the amount that you're going to be leaving them is not something that you would think would warrant leaving it in trust. Again, I mentioned those clients that will choose to leave the assets in trust for their kids. Many times they're looking at the benefit of being able to leave those assets in trust for their children, and to be protective against those assets being taken in a divorce. I also see it where there are grandchildren or children of that child, and they want to make sure that whatever's left over in that trust, when the child dies, if they have not done their own estate plan, Whatever's left in that trust when the child dies will typically, and we will, of course, you can change that option, but typically the default would be the remainder would go to your grandchildren or that child's children. Okay? So these are some of the options here.